Okay. Well, I'm going to get started here. Good afternoon, everyone. I think people will keep filtering in, but let's go. My name's Gary Schuster. I am a partner here at Jacobowitz and Gubits in Walden, New York. We have David Serrano here with us as well. You can see David. Wave. Hello, David. David waves hello from Harvest 360.
Good afternoon.
My colleague, Marissa Weiss, is having some camera difficulties. I'm sure she'll be on soon enough. So welcome, everybody. Appreciate you being here. And as you all know, legislation was recently enacted in New York to legalize marijuana in various ways, and we are going to talk about that and what it means for our community. So let me try to share my screen. There we go. David, am I showing the right thing? Yes, I guess I am. Okay. There we go. So introductions. Okay, we don't really need to get into the agenda. We'll just get right into it. Jacobowitz and Gubits is a full-service law firm here in Walden, New York. We largely work in the lower Hudson Valley, Sullivan, Orange, Ulster, Dutchess, but we work all over the state, really. We have clients from all over. We've got about 20 lawyers, 20 support staff, been in business since 1968. We have 30 areas of law. We do pretty much anything that anybody in the Hudson Valley will need. Business, estate planning, litigation, lots of municipalities, family law, and so on. I personally work in business. I do a lot with nonprofits, copyrights and trademarks, estate planning, guardianships, and so on. Marissa, who is still having some technical difficulty, is in our municipal area, and she works on land use, works with planning boards and zoning boards of appeal and such. And she is sort of our chair of our marijuana little group that we have called the Marijuana Committee to study these new developments and so on. We're also very happy to have with us David Serrano of Harvest 360, and I'm going to let him take 30 or 60 seconds to talk about who and what those things are. So David, please have at it.
Thank you. Yes. Well, first, thank you for having me on the presentation. We're very honored to inform the community about these recent events and the opportunities at hand. Harvest 360 is a full-service consulting firm. We specialize in startup business development, applications, technical writing, doing regulatory work, and helping folks engage their communities in a positive way around new cannabis business development. We also work with a number of government officials and agencies across the country, and are proud to be one of the leading companies in the space, ushering in a path for social equity applicants, which are the communities most impacted by the war on drugs, and as well as working with counties, municipalities, and states on helping inform them on the opportunities and how to create pathways for those communities that have been most impacted by the war on drugs.
Terrific. And I'm happy to see Marissa's here. Hello, Marissa.
Hey, I'm sorry, everybody.
Better late than never. Why don't you, let's see, first of all, tell us a little bit about your areas of practice, and then we can dive into this facts and figures, which is your information.
Sure. So everybody, I was left out of the conversation for a little bit in the beginning. I'm sure he already introduced me a little bit, but my name is Marissa Weiss, and I'm an associate attorney here at Jacobowitz and Gubits. I do land use, municipal, and environmental law, as well as I've been working in the hemp sphere for the past several years, and now that's transitioning over a little bit more to cannabis, which is very exciting, and we're trying to navigate this new world as best as we can, and working along with all you folks to help navigate and provide legal assistance as well as business development assistance with those such as David and his company. So I wanted to throw up a couple of facts and figures, not necessarily to read through them, but to kind of give everybody a navigation point for where we're starting out today. The overall theme of today's presentation, what we'll talk about, Gary and myself on the legal side, but also David on the business side, is that while this is very new to New York State and new to us regulators and business development, as well as lawyers and municipalities, those municipal officials who may be listening right now, it's not new to the rest of the states. We are the 17th state to legalize, if you don't include, of course, the territories of DC and Guam as well. It's also all those other states are also influenced by the international markets that play between those state legalization mechanisms. So while it is new to us and we are trying to figure things out, we would caution you that everything that we say today, keep in the back of your brain that you really want to be thinking about how to move forward if you're considering, just being a consumer, or if you're looking for a license in any way, shape, or form, or maybe you're a municipality that may want to opt in or opt out. You should be considering those items now. Similarly, New York State, it's projected that over 60,000 jobs, 350 million in tax revenue, as well as 3.5 billion in economic activity is going to be spurred with the inaction of this MRTA law that we're going to discuss a little bit more today. That's money, jobs, revenue that we want to stay in New York State. So we are trying to best navigate this world, figure out the way to best help our clients or potential clients, as is David, and we want that money to stay here. If you could go to the next slide, please, Gary, that would be great. And with all of that being said, we're trying to work towards it now. It's something that you want to be thinking about now and not put on the shelf until later, even though we're going to discuss how those regulations haven't really come out yet. So there's a lot of unanswered questions, but you should be working now towards, moving forward. At the same time, I don't want to be, a buzzkill or anything, but if you take a look at the last bullet on this slide, marijuana still, even with the inaction of this MRTA in New York State, it's still classified as a Schedule I controlled substance according to the federal government. So you have this very weird dichotomy where the past two slides have talked about all the people using, all the different markets that have grown, all of the very lucrative markets that have grown out of legalization in these other 16 states, as well as those two territories. At the same time, while the federal government isn't actively pursuing any state or state licensee under that state license program, for federal crimes or offenses, there's still that issue on the back burner. It raises a lot of interesting questions for municipalities specifically. How do you both uphold state law while also upholding the federal law, which we'll talk about and briefly touch on later. But just generally for consumers as well is, are we concerned that we might be okay in New York State, but there are questions of federal law and federal crimes that could arise as well. If you could go to the next slide, Gary, that'd be great. So we kind of touched on this already. This is really just a grounding slide for moving forward. But the MRTA created a comprehensive regulatory structure that oversees the licensure, cultivation, production, distribution, sale, and taxation of medical, adult use, recreational, and cannabinoid hemp. Now, that was adopted on March 31st. So we're approximately 2 months in, there's still no regulations. That's just the statute that sets up the framework for moving forward. In its wisdom, New York State did create its own Office of Cannabis Management to kind of head everything, all those 3 different types of licensing programs. Prior to now, and all the work that I've done in the past couple of years in the cannabinoid hemp field, I know there's some of our hemp clients that are listening, so they know this intuitively already, but that was all headed under the Division of Agricultural and Markets. And this weird subset category that they didn't really have an umbrella for. And it was kind of confusing, who do we address things to, where are the regulations coming from? Very confusing. At the same time, those medical marijuana licenses, which we're not really going to talk about too much today, but be aware that they're out there, were headed under the Department of Health. So now going forward, everything is going to be headed under this new Office of Cannabis Management, which also is going to include a Cannabis Control Board. moving forward. And all of those players, you know, those are just names at this point. There needs to be people actually appointed to have that actual office, as well as that control board as well. That hasn't happened yet. So that's step one. So we're not even at that stage yet. But at the same time, at the rest of this presentation, we want you to continue to think about those steps that you need to take to move forward. It's just because we're waiting and to see what those regulations may be, doesn't mean that you shouldn't be thinking about it now, because those other states and even international markets have already thought about it and have, you know, perfected that model within the other legalized states. So we want to make sure that you're able to do the same thing ahead of the game, just as they have. And to give a brief overview as well, for individuals, while those regulations are not adopted yet, as of March 31st, it's legal. You may have noticed, I live very close to New Paltz. There's quite a smell of marijuana going around New Paltz that you didn't typically see, or it wasn't as open as it used to be. You know, New Paltz is New Paltz, but a little bit more open than it used to be. People are a little more cavalier as of March 31st. Similarly, you're also allowed to possess up to 3 ounces of the flower in whatever form that may be, and up to 24 grams of concentrated cannabis, which is, you know, the oils or tinctures, anything else that's in a concentrated form. At the same time, however, you're still not allowed to operate a vehicle or use on work premises, and it's also prohibited, where smoking tobacco is prohibited as well. And that brings up interesting questions for municipal regulations that we'll talk about a little bit more later as well. Similarly, and I'm sure David will mention this in his portion of the presentation, but it also has, as part of this law, it was very important that there be socioeconomic considerations that were taken into that law. Those records are automatically expunged for anything that is now legal. So for instance, if you were convicted of a crime for holding or possessing up to 3 ounces of flower at some point in your life when it was criminalized, that record is automatically expunged now. Something that's also interesting, under the regulation, home grow is allowed. So you are allowed to personally cultivate, I believe it's 6 immature and 6 mature plants. However, most people, when they saw that this regulation came out, they thought that that was immediately legalized. It's not. It will not be legalized until 18 months after those new regulations are put in place. And then after that first adult use retail sale occurs in New York State. So really the intention of the state there is to get that commercial activity, that legal commercial adult use recreational activity solidified. And they want those businesses to be able to make money without people just going to their neighbor down the block and getting whatever product that they're looking for. So that's really the intention there. Gary, could you go to the next slide, please? So before I turn it over to David, who's going to talk a little bit more about the licensing scheme and his experiences with his business in the other states that have legalized, we wanted to point out 2 of the types of licenses that are really important, and you've probably seen some discussion about within the news. And those are 2 types of commercial marijuana retail sales direct to consumer. Those are your retail dispensaries. And that's like, if you've ever been to Colorado or one of those states that's been legalized for a while, that's like your cannabis candy store, basically. You can go in, it's a storefront where you can obtain marijuana products. You go in and you pick out exactly what you're looking for, or have somebody, you know, lead you in whatever thing you're looking for to do. But you must take them away. You cannot consume them on the premises. On the converse side, you also have these on-premises consumption sites, which is a mouthful, and we kind of just prefer to call them cannabis bars, basically. So just like an alcohol bar, which is such an odd phrase to say, but now we have to preface which type of bar we're talking about with the adoption of this law in New York State. A cannabis bar, which it's like a lounge where you can go and purchase whatever type of marijuana products that bar is selling, but you must consume them on site and you're not allowed to take them off. David actually introduced us to a very interesting term that Gary and I both love. But instead of a bartender, they are calling those bartenders of the cannabis products bud tenders at these locations, which is very interesting, a word that I never thought I would have to say, but it's an exciting new term that we're all learning in the legal sphere as well. With that, I'm going to let over to David to talk a little bit more about the different types of licensing schemes, as well as the social equity component, which is a really interesting part of this New York State law.
Thank you, Marissa. And yeah, we're excited to introduce the #1 job in the industry, the bud tender role. And that is the forward face of the industry, the point of engagement with the consumer. These are knowledgeable retail folks that know a lot about the plant and the products that they're selling, and really their job is about safety and making sure that people aren't over consuming and understand the products that they're taking. We'll talk about the licenses. So there are various license types. There's cultivator. These are people that are going to strictly cultivate the plant, and they can't sell that plant directly to the consumer. They can only sell that plant to a distributor or to a processor or to a retailer. In fact, the only person that can sell directly to the plant is the retail operation. The processor is someone who's going to now purchase that plant from a cultivator, and they're going to extract the cannabis oils out of it, the various cannabinoids, terpenes, flavonoids, the things that people are seeking for consumption. And they'll extract it and they'll process it. They'll further distill it into different types of products, to even down to a monomolecule, which we now know as the pure pure isolates. The distributor license is a license that enables a person to acquire, market, and sell cannabis within the supply chain. Again, the distributor cannot distribute outside of the supply chain. The only person who can sell outside of the supply chain direct to the consumer are the retail folks. And that kind of summed up the next license type, the retail dispensary license. The on-site consumption license, similar to a bar, you're able to sell product in the space. You're not able to take that product out of the space and consume it. And so it's going to be this is a new trend in the industry. California has some variations of it. Colorado just recently, after all these years, are recently allowing more formal license practices, and as well as in New Jersey, you'll see that in the language there, and now in New York. So this is a really interesting area of the industry, which I think, because of our demographic, because of our culture in New York City, this makes absolute sense to have. The micro business license is really, really interesting. I remember when Senator Kruger gave a presentation about this some years ago, and she referred to the microbrewery industry and how they created those laws and what their intention was for that, to enable small businesses to produce cannabis, extract it, cultivate it, extract it, and sell all on the same premise. It's a new type of license that we haven't seen anywhere in the industry. New Jersey has a micro license availability, but it's not like this. This is a full vertical in a small space, whereas the New Jersey micro licenses are specific to each of those license categories. You can only have a dispensary, but it's capped at square foot. It's capped at how many plants you can sell. Similar to the micro license in New York, although we don't have that information, the Office of Cannabis Management will put out those rules. What does it mean to be a micro license in terms of your square footage? Expect some sort of caps on the square footage, and as well as the plant and the material that are moving through those spaces. Delivery license. Again, the delivery folks are going to be working on behalf of the retail folks. You can't have a delivery directly from a cultivator or from a processor. Delivery will be titled working with the retail locations to get product into the various communities. Nursery license. This is specifically to grow the plant to a certain size, and then you got to get rid of it. You got to sell it or destroy it. And the people that would buy that would be cultivators. A cultivator is allowed to hold on to a nursery license, and vice versa. Small business cooperative license. This is going to be a really interesting area. It hasn't been really well defined. I mean, they do say, they do lean on what they say the traditional co-op model, where it's owned by and controlled by a group of people, and so there still needs more further clarification on that. And before I end here, I'll kind of talk about that clarification momentarily. The registration organizational license. So these are going to be medical. It's not determined when these are going to drop. It does say in the law that they're making way for this, and it's still unclear if this is going to be when it's going to be rolled out. But it's not going to be rolled out. Likely will not be rolled out at the same time. Now, the Office of Cannabis Management, as Marissa explained, is going to be the regulating authority for all of these license types. It's important to note that they're going to have open commenting periods, and they're going to have a process of evaluation and rule making. And this process will take some time. During that process, a lot of the details, the things that the law does not provide, the square footage, hours of operation, security requirements, the fine details, all of those come out in the rules, in the regulations. The Office of Cannabis Management would manage those things. I think there was, is there another slide to this, Gary? No, okay. So
No, there is not.
Okay, in preparation for these licenses, any of these licenses, the first thing that any company needs to do is identify your team. You identify, and we work with folks, in Illinois, Missouri, Kansas, Colorado, Oregon, East Coast. The first application that we ever wrote was in Virginia. We competed for one of the 5 big license types and won one of the 5. And in all of these processes from state to state, there's always, commonalities. And these are the things that people can work on today. And that's going to be working on your team building. And your team needs to have a corporate structure. And guys like Gary are standing by to support with a tremendous amount of experience in understanding how these corporate structures can protect you and your partners. And this is the absolute work that needs to be occurring now. You don't want to start building your team when the application drops. That would be a mistake. The next thing, and then on top, to stick to that, building a team is super important. You have to build your team based on the type of license that you want to go for. So you want to look at all of the experience in your team and match it to a license type. So for instance, if you have a bunch of people that have worked in retail at high levels at Macy's or where have you, and you're going for a cultivator license, that might be a mistake. You might want to lean on the strengths of your team. And consulting firms like mine and others, we advise on that. So we bring teams together, we extract all of the applicable backgrounds, and we try to match it with the license type. Now you have a mission. And what does that license type require in terms of real estate, funding, business planning? All of those things you can start doing today. The information's available, and there's support in the industry for folks to get started up. And then that just creates a slew of legal work, real estate work, that needs to get done before these applications drop. Because if you can imagine, all of these things also do cost money. So oftentimes folks that don't have a ton of it have steady income, enough expendable income on a monthly basis to cover a project. This may be it will be a better approach to start incurring costs now and not try to rack it all up in a span of 1 or 2 months, and then it can be unreachable. And so understanding what those costs are and starting to engage in them and budget and build your team, identify your real estate, your plan, all of those things are super critical to do right now. Because when the applications drop, they don't stay open for a very long period of time. We don't know exactly how New York is going to operate. Historically, applications are open anywhere from 30 to 60 days. And that's from other states. We hope and will be urging the state to make the application process easier, more open and fair, so that folks can get in the space with less barriers. However, just based on the historics and how these things come about, we know that that there is a strong possibility these periods of open application can be rather limited and make it very difficult to organize around an effort. I think I'm done. Oh, social equity. So I'm a social equity applicant. What makes me a social equity applicant? Well, I'm a minority. I have a minority-owned business, and there are 5 different types of well, there are 5 categories of social equity applicant, and the first one here, individuals from communities of disproportionately impacted area. That's going to be that can be included or for specifically the minority-owned businesses. Women-owned businesses, either distressed farmers, service-disabled veterans. The one that's missing here is going to be your formerly incarcerated person. So if you have a conviction, and I'm sorry, this was my bad, I missed that on the slide. If you've been formerly incarcerated for a cannabis charge, you're going to be a social equity applicant. And so what does it mean, for the state? It means a big deal. The entire intent of the law, according to people, Stokes, who spoke about this just last week, was that the intent of the law was to create repairs to the communities that have been most impacted by the war on drugs. So these various levels of social equity applicants, in one form or another, have been disproportionately impacted by the war on drugs. We make a case I'm also a service disabled veteran. I was medically retired by the Navy and have a high compensation rate. My disability, was treated through narcotics and what I would say not the best ways. And so the government recognizes that they were withholding good medicine from disabled communities, and this is kind of how we were injected into the social equity class. Distressed farmers. This is specifically related to financially distressed farmers. You need to be able to prove 3 years of distress as a business. Any of these categories, especially the minority-owned business and the women-owned business, there are state certifications for those types of businesses. Also something that Gary could help on. Those are basically qualifying your businesses that they are indeed owned and controlled by either a minority or a woman or a service disabled veteran. And the state, in my last point here, the state said we have a goal of giving 50% of all of the licenses to these groups. And that was based off of the intent of the law, which was to create repair for the communities most impacted by the war on drugs.
Okay, thanks, David.
You're welcome.
And I know there are a bunch of questions in the chat about specific licensing schemes and exactly how that's going to work. There's some social equity questions as well. We're going to try and answer all the questions at the end because we received quite a few as well up front from the attendees who I hope are listening today, but at the very least, we want to answer all of them at the same time. So we'll do that at the end. Now, with turning over to the municipal power. So I know that there are a lot of our municipal clients listening right now, as well as some other entities as well that are concerned with or have just heard about this municipal opt-out power. So to demystify the situation a little bit, that opt-out power, it's an interesting phrase that they use, but basically it means that municipalities are empowered to make the decision, which is authorized under this MRTA, to prohibit dispensaries and or on-site consumption facilities, those cannabis bars that I was speaking about a few slides ago, from locating within those municipal borders. And once they make that decision, the Office of Cannabis Management is prohibited from issuing licenses for those 2 types of licenses to any applicant within that municipality. So of course, up front, you don't just apply for a license for a dispensary or for a cannabis bar, just anywhere within the state. You apply knowing that I want to be in a specific town in Orange County, like where our office is located. So up front, you would know that, and it would not be a secret. So you would need to find a municipality that is going to be friendly and hasn't adopted one of these opt-out laws. Now, I've seen a lot in the news. I've written articles. We have articles coming out actually in the chronogram in the next couple of weeks. So stay tuned for that as well, talking directly about the municipal power. But everybody is kind of centered around the fact that that opt-out, which is via local law, and for anyone on the call that is a municipal official, they understand that you don't just adopt something, you have to have a public hearing, all that kind of stuff with a local law. So it's not a immediate thing that happens. You need to plan for it up front. But there's a lot of confusion in the news about what that date of December 31st exactly means. So that the MRTA specifically says that that opt-out law that you pass has to happen by December 31st. So we've had a lot of clients come to us and ask, what exactly does that mean? That's quite a few months from now. There's no regulations yet. How are we supposed to know if we want to opt out or, not opt out, which conversely means you're opting in if you do nothing. What exactly that means? How are we supposed to know yet? And we completely agree with you. I think it's kind of crazy that you're being asked to make a decision as a municipality or as a community constituent about what you want for your community when you don't really know all the facts yet. And unfortunately, that's just kind of where we are, because the fact of the matter is that your municipality can go whatever direction they want, right? As a constituent, you might want to influence them one way or another. If you're thinking about encouraging or discouraging your municipality, you might want to start working with that municipal board right now, because unfortunately, or fortunately, however you look at it, there is a requirement in the statute, in the MRTA, that a permissive referendum is allowed for if a local law is passed. So basically that means that your municipal board would put out and introduce that local law, and then they could not adopt it until a period of time passes. It's different for villages versus towns, but for towns, that's the majority of our municipalities, it's 45 days. They have to wait in order to formally adopt that local law and file it with the state, which would put it on the books and prohibit anybody from citing those dispensaries or bars within that municipality. They have to wait 45 days to make sure that somebody doesn't ask for a referendum, which is essentially just putting it on a ballot and allowing people to vote for whether or not they want to see that local law be adopted, which would prohibit those facilities. And based upon the timing of how that works, for most people understand, especially our municipal officials, that voting costs money. So we have been counseling our municipalities that they really should be considering the fact of timing this local law adoption if they choose to do something like that with that general election, which will happen on November 2nd. So we're going to do a more in-depth webinar to talk about this a little bit more later in the month. So please stay tuned, and anybody listening to this webinar today will get that email blast, like I'm sure you got a bunch about this meeting today, that'll talk a little bit more in depth and help plan for exactly how you want to accomplish that, whether you're a municipal official or just a community member looking to influence one way or another. Please be on the lookout for that, but you really should be considering it right now, because based upon those deadlines, you're essentially looking at, if you want that referendum, if it's called for to happen at the general election on November 2nd, you basically need to adopt your law sometime in July. And again, we are going to put all those dates out there to help. We have been working with our municipal clients that are existing, but if there's anybody who wants to talk about it a little bit more, we're of course welcome those questions. You'll have my email contact at the end of this presentation. We can talk about it a little bit more. But again, as I said in the beginning, the overall theme is, that December 31st date looks really far away, but it's not in actuality. We're almost already in June. So it's something that you really should be discussing, with your community members, with your other board members, with the larger county, if that's something that you're concerned with as well, how the counties are going to work together, or how the communities within each county are going to work together. It's something to really be discussed right now. The other converse thing, which is very complicated, and it's just why we're trying to do another webinar specifically on this subject, is the fact that even if you opt in, you don't pass a local law that prohibits those dispensaries or on-site consumption facilities from locating within your borders. You can have the option of adopting time, place, and manner restrictions. It's a term that comes from basically constitutional law, which is very interesting that the way the MRTA was written includes that constitutional law issue. I guess, you know, being able to cite your cannabis facility is considered a constitutional law issue under the MRTA, which is kind of interesting. But those regulations would be some form of zoning restriction. And based upon what we've seen in surrounding states, you know, most notably Massachusetts, but I'm sure that New Jersey is on the forefront as New York is. They're kind of competing right now for who's going to get, you know, the newest licensing structure, who's going to start, you know, get that up and running quicker. And I'm sure David can talk a little bit more about that if anybody's interested. There are new zoning regulations that you could potentially look at, such as distance requirements. It's already written into the law that you have to be a certain distance away from schools and religious institutions, but there are the opportunities for municipalities to increase those restrictions, make it, you know, a longer distance away. There's also talk about potentially having a restriction that would prohibit concentration of these licenses. So you wouldn't want, you know, multiple bars within, you know, a certain distance of one another. You might get or dispensaries as well, of course. You might get like a different vibe to your municipality that you weren't really looking for, or the municipality doesn't want to, they don't necessarily want to prohibit entirely, but they don't want to become a mecca either. There's signage requirements. I would caution that you have to make sure that they're all content neutral, another First Amendment concern, which some of our municipalities are very intimately familiar with. You can't create signage regulations just for one type of sign. So you can't say all cannabis signs need to say X, Y, and Z, or can't be this size. It needs to pertain to you know, all different types of content, not just cannabis. And then potentially there's been some discussion about whether or not planning boards are going to be allowed to require special use permits or any other type of permit to make those facilities go through the planning process. Again, we don't really know if the new regulations that are going to come out that David was speaking about are going to speak to that a little bit further. I would assume that they would, but at the bottom line right now, it's something that your municipality should be thinking about. Those restrictions need to be reasonable, and that's something we can certainly provide guidance on as well. And with that, I'm going to turn it over to Gary, who's going to talk a little bit more about the taxation issues, which is one of the things that is the reason why a municipality would want to opt in and not have.
Thank you, Marissa. So there are taxes here. This is, I guess, part of the reason why so many states are pursuing legalized marijuana. So there's two elements to this. Where a distributor sells a product to a retailer, depends on the product. You can see there are flowers, concentrates, and edibles. And so the tax rate varies depending on the product. When you have the flower, it's 1/2 cent, 1/2 penny per milligram of THC as indicated on the label. Now, all these products have to have labels, and much like any food and drug product. And there are regulations coming. How do you measure these things and so on? What has to be on the label? So that is yet to be seen, but depending on what the label says, how many milligrams of THC in the product, 1/2 penny for a flower, 0.8 penny per milligram on the concentrates, and 3 cents per milligram on the edibles. So that is where the distributor sells to a retailer. And now when the retailer sells to a consumer, there is 13% where you can buy it, because 9% goes to the state, and 4% goes to the town or village or city where the sale takes place. Worth noting, New York City, as in many areas of the law, is its own animal. They don't treat the boroughs like counties and so on. So if you're active in New York City, it bears a little further looking at the law and regulations. But for the rest of us upstate, this is how it breaks down. 9% state tax and 4% local tax, unless, of course, the locality opts out, and they're going to miss out on that revenue. Okay, what are they going to do with those taxes? Well, half of it goes to what they're calling the Community Grants Investment Fund. It's intended to finance community education and training programs. As David was referring to, a lot of this is intended to be remedial, to remedy a lot of damage done by the drug wars, and to help communities thrive. 25% goes to the Department of Education. So just like Lotto, the money goes to the Department of Education. And the other quarter goes to drug treatment programs and education. Now, how are these funds going to be allocated among various programs and localities? We don't know yet, but that is the big plan. So the regulations, as we've often said, are still being written. They're not out yet, and we'll know more in a couple of weeks or a couple of months. Now, as a business owner, there's a very important issue to be aware of, which we call the Internal Revenue Code 280E. And that section of the Internal Revenue basically says if you are involved in an illegal business, you cannot deduct your business expenses when calculating your taxes. So if you're a business and you have gross revenue from your business, you're entitled to deduct your expenses. What did you spend for advertising and payroll and utilities and rent and so on? You're allowed to deduct all that. Then you have your net income, and that's what you pay your taxes on. What the Internal Revenue Code says is, no, if you're in a legal business, you can't deduct all those expenses. And marijuana is still a Schedule I controlled substance. So from the federal tax point of view, it's an illegal business, and you cannot deduct the ordinary and necessary business expenses like every other business. Now, if you look at the bottom bullet there, it says you may deduct the cost of goods sold. So there are certain elements of your activity where you can deduct the business. So if you're a processor and you buy raw material from somebody, that is part of the goods that you're selling. It's part of your cost of goods sold, and you can deduct that amount from your gross income. And there are some other snipping the buds, and you can get into the real weeds. You can get into the details about what is actually physically done to the marijuana. Some of that will qualify as cost of goods sold, and a lot of it will not. Part of what we're doing here at the law firm is trying to find accountants in our region who are familiar with these things. I bet a lot of them are not. So we're all learning. I've read some very detailed articles in the last few weeks about cost of goods sold and activities and expenses that qualify and those that don't. And in other places in the country where people have been living with this for a while, they're coming up with all sorts of clever corporate structures so that the company that handles the marijuana isn't necessarily the company that hires the staff, or isn't necessarily the company that pays the rent. So that the enterprise, which is comprised of several entities, kind of like a conglomerate, the enterprise finds a way to deduct those expenses, even though the entity that is actually handling the marijuana cannot deduct it. So this is another reason to start early, start planning early. What is your intended activity, and how is it best structured? And this is a question for the accountants, for the lawyers. I was just reading about insurance as well. There are some insurance industry challenges in this field. So the best advice, which is what David was saying, is to start early. Talk to your professionals and plan, because you can't, if you make it up as you go, it's just not going to be effective and cost efficient. Let's see, what's next here? How can we help you? How can J&G help you? Well, we do a lot of things here. As we've said, we've got about 20 lawyers and 30 different practice areas, corporate, We work in a lot of real estate, from the largest shopping malls and housing developments and industrial sites down to single family homes. Your business wants to buy land, lease land, have an office space, whatever, we can do all of that. We form the corporations and limited liability companies, and we form those conglomerates that interact. For instance, we always put real estate into an LLC, which may pay rent to the operating company. I'm sorry, they may receive rent from the operating company that's actually doing the work. It could be a whole other webinar on that. Certainly work with banks. I didn't even mention that going back. Banks are also largely prohibited from handling this money. So that's another element of the challenge here. You can't be a marijuana business and just put your money into a typical bank. So how does that get resolved? So there's more planning needed on that. We do employment, and we do, all these things that are listed here. We do pretty much anything a business in the Hudson Valley needs. And I'm going to let David talk about what Harvest 360 can do to help you.
Thank
David,
you.
You have 2 minutes.
2 minutes. So I did speak about this. We support with cannabis business startup consulting. You need a business plan. You want to figure out what you have and how you can apply it to this industry. We're going to be the people to call. And then if you decide to submit an application, we'd work with you and get your application across the line. We do as well economic development programming and management for governments. And so if folks are trying to figure out how they can enable their community to have better access, less barriers of entry, thus more tax revenue for you and your community, we can also assist in that matter. I would say and I'm going to put my information here in the chat.
Oh, David, you went off. You hit mute, David.
I was saying I was going to put my information here on the chat, and I hit mute by accident.
So we're going to have a screen with all that. So.
Yeah, there's a screen at the end as well, David.
Okay.
That has
on a note, if I'm in a community that's banned, cannabis, I could still, promote a delivery service within my community, and so people can still consume. There can still be transactions. I was just thinking about that earlier. The opt-out would only prevent tax money for your community, and still you're going to get cannabis, into the community. You're able to grow it, you're able to extract it. I know that that was kind of covered, but I thought that maybe just to put that plug in, it's for the applicants' sake. But this is also something else we do. We are advocates. My partners. We work with the government and communities to elevate their voice and help create more access to the industry. We're 100% motivated to reduce those barriers and want to support at a business level as well as a community level.
Okay, thank you. Now we're going to do some questions and answers. You don't need to look at that slide, but here's our contact information. And what I'll do is please, David and Marissa, take yourselves off of mute. We're going to go back and forth. We got some questions ahead of time, and we've got a number of questions during our session here, so I'm going to try and spread it around. First one comes with a lot of questions about licenses. What is the timeline for the applications? Will a scoring system be used? I'm going to think that we don't know that yet. David, do you have any better insight on that? No,
we don't know that yet.
Okay, so the license process is largely unknown right now. Another question said, will New York State be available? Will New York State make grants available to disabled veterans to assist them in starting these businesses?
There is a mention in the law regarding incubator, that the state would fund incubators, and so I assume that the incubators would service the social equity applicants, thus serving the disabled veterans. So you may not get a direct check into your account to operate your business, but what you may get is a path to ownership through intensive training and licensing application support.
Okay. Let's see. Can you have an on-site consumption and a delivery license? Who wants that one?
Oh, I actually have a note on that. If you give me one moment, I can give you an answer, unless Marissa, you have it on offhand.
I don't. I think.
Oh.
Go ahead. I have something to add, but I want you to be able to
It
answer.
says no person may own more than one delivery license. No delivery licensee can have an interest in or own another adult use license. That's your answer.
Okay,
No.
so the answer is no. Also, we should tell you that there's a limit of 3 licenses. So if you have a dispensary, you can only have 3 dispensaries. If you have an on-site consumption site, you can only have 3 on-site consumption sites. The idea is here they don't want powerful players monopolizing the business. They want a lot of ownership spread around. So that's an interesting element here.
Yeah,
I will say, having looked at this, it's very much like the liquor laws. You have to notify the municipality that you intend to do it. You have to have a lease, or you have to own your real estate. It's very similar procedure.
Yeah, which makes total sense because it is headed under the state liquor authority. We talked about a lot of entities and acronyms today, but the overarching umbrella for this Office of Cannabis Management is the state liquor authority.
Okay, let me go for some more questions here. In the legislation, it states that at least 51% of the business must be owned by a social equity applicant if you want to benefit from that. In the event a business is owned half by a service-disabled veteran and half by a woman, does that mean we would not qualify? I think the answer is you would qualify, but it remains to be seen because both of the owners are eligible. So that's my best guess without having seen it.
I would assume that that's probably come up in other states.
It has, and it typically boils down to what certification you get to prove that position. And most of those certifications require a 51% position and controlling interest in order to be granted those certifications. There are some instances where you can lump, various veterans together for some sort of for that 51% position. But we don't know if New York is going to do that yet. So what we're recommending right now, if people wanted to get ahead, is to get a state certification for either what we call MeBe/Weebie or disabled veteran, women-owned, or the minority-owned business or disabled veteran.
All right, next question. This is about micro business. Can it be vertically integrated, which is to say cultivate retail and distribution? Does the grow and retail location have to be in the same spot?
So likely it will have to be in the same location because of the nature of the intent behind the microbrewery concept. Taking that and bringing it over to the cannabis industry. It's traditionally been all in one location. There will be an allowance for a distributor license to be associated with the micro license. However, that distributor license can only sell and distribute products from that one micro license. You couldn't go out to the world and try to buy more product and sell into your supply chain. You can only represent your micro facility.
Okay, here's another question. What is the advantage to a business owner or a municipality to having both a dispensary and consumption lounge? Well, I'm going to take half of that, which is to say that if you own a dispensary, you cannot have a consumption lounge and vice versa. So you have to choose one. But on the municipal side,
yeah, so there's a couple of questions I think we have 2 sets of questions going on here. We have the question and answer, and then some people are putting them in the chat. So try to address a couple of questions at the same time with regard to that. We did speak, mostly about the benefits of legalizing and, not opting out. So you're opting in, so you're doing nothing and allowing those dispensaries or bars to come into your to your municipality, which would be chiefly that taxation issue. And I did see some people clarifying within the chat, just for everybody's edification, that 4% of that 13% tax that's going towards the localities, as Gary was describing, 75% of that 4%, so 3%, is going directly to those municipalities that host those facilities. And then 1% is going back to the county. And the county is going to distribute that money. They do it quarterly. They'll receive it from the state, from all the tax revenue that they generate, and then it has to be allocated appropriately. So the main benefit, if you do opt in, is to allow, that tax revenue to come back. However, that does necessitate, a two-step process there, right? So you're opting in, but that doesn't necessarily mean that that municipality is going to get any licensees that want to, open up shop within that municipality. So if you're a municipality that's looking to do so, you want to think about those incentives that you're giving. Is it a good tourist destination? Do they think they're going to get a lot of traffic? That sort of thing. Conversely, if you're a municipality that doesn't want that to happen, you might have reasons that you're concerned about, whether or not we're not, proselytizing about whether or not these statements are true, but there are concerns that it'll bring in crime, that it'll be less safe in regard to if you have those facilities located within your municipal borders. That's generally the concern we're seeing for most municipalities, which is where those zoning regulations could come into play if you decide to opt in. So all is not lost. You can still control some aspects of that business, just not all. But that's the main concern that we're seeing, just proximity to mainly residential uses. So that's really the caveats there to opting in, but at the same time, you have to balance that tax implication, as well as the fact that what David was speaking about with the socioeconomic components. If you're a municipality, or at least within an area of your county that has a lot of previous incarceration rates due to marijuana crimes, and you're trying to remedy that, or if that's important to you as a municipality, to be kind of a beacon of hope for those communities, that they can kind of come back from that history of anti-cannabis influence that's been going on for decades at this point. If that's important to you, then you might want to be a municipality that sends a message to not only your residents, but around the surrounding municipalities, surrounding counties, even outside, when other people come to your municipality, that you are looking to promote, and that's something that is important to you, remedying those wrongs of previous anti-cannabis criminality and campaigns that happened for the past couple of decades. So I think that I'm trying to make sure that I'm getting all the questions that came up with regard to that, because there's quite a few about that specific topic. I'm reading. Gary wants to chime back in with any specific things.
I'm going to just read another question here so we get it around a little bit. Any thoughts on zoning and distance from schools? Do you think it will be similar to other states? We know that answer. I'm pretty sure it's 200 feet.
Yeah, Gary, it's 200 feet from religious. I hope I'm not mixing that. Going backwards. No, it's 200 feet from the religious institutions and 500 feet from schools.
Right.
But there are, as I said before, we're envisioning, again, the regulations aren't out, which are going to give further guidance, but we're envisioning that municipalities that opt in would be permitted. It would be considered a reasonable regulation to add in more strict regulations with regard to distance. And as I said before, similarly to a lot of our municipalities have concentration zoning regulations about how close some of these facilities can be to one another. So I would think that it's our best guess that that would be considered a reasonable time, place, and manner restriction as well.
Marissa, I want to also add to that, if I can, with respect to safety, this is constantly, something that comes up, and I thought that it's really important to point this out. When you set up any cannabis business in any municipality or anywhere in the United States at this point, what you're setting up a structure with hundreds of cameras in some cases, depending on how big the facility is, and what it's done for crime prevention across the country has been remarkable. And it's an unsuspected effect, you know, that legalization has had. All of a sudden, law enforcement now have eyes and ears all over their communities, and they can investigate crimes. They can walk into a dispensary and request, you know, one of the many cameras that are pointing to the street and 360 degrees around the building, you know, and seek evidence, and that has led to solving crimes. And you know, so this is a you know, something that I think that's important to debunk. You know, that bringing to allow retail facilities would create more crime or an unsafe situation. In fact, the truth is the exact opposite. And oftentimes the worry is that people from outside of the community that don't reflect or look like that community might come in to that community. And I don't really think that's a good business practice, but I think when all of these things are kind of analyzed, that's what you're left with if you're a municipality and still trying to figure out whether to opt in or opt out. You know, I think safety is a huge concern, and you should opt in.
All right,
David, yeah.
we're over time. Marissa, got one last thought?
I have one last thought too,
Go for it.
for our municipal clients or just generally residents who are interested in that power and might want to influence their municipality one way or another. We've heard a lot of talk about municipalities deciding that, okay, let's just opt out now, why there's no regulations out, we don't know what we're getting into, and then later, I think I kind of glossed over the fact that you can always opt back in, right? The state authorizes you to do so. You have to opt out by December 31st, but you can always get back in. We would caution against just doing that as a gut reaction. You really should have some reasons for doing so. And you know, whatever your reasons may be, that's fine. But you should think about it more concretely, which is the point of this presentation, the upcoming one we will do, because you're really signaling to those businesses that, you know, why would they want to come to a municipality that has prohibited them, you know, previously? Would they really want to site within that municipality going forward? They were already figured out more cannabis friendly municipalities to go to, you know, gotten funding to do so. They're thinking of all these things up front. You should really not just jump into that decision and, you know, make that educated decision yourself by talking to your constituents, by talking to the rest of your board members, by talking to, you know, if we are your lawyer, talking to us. If we are not, you know, potentially we could be in the future, or, you know, talking to your own municipal lawyer as well about this issue. And with that, I think we're good to go. But as I said, we're going to do a second webinar as well, more on the municipal issues. So please keep posted, look at your emails, look at our website, look for our articles that are coming out in Chronogram, and I believe some more local papers as well over the summer.
Okay, very good. Thank you, David. Thank you, everybody who's attending. Please feel free to email us or call. That's why we're here. And 4 minutes over. Is Zoom going to cut us off? I don't know what they're going to do. Stay tuned.
You're good.
Thank you, everybody.
Thanks, everybody.
Thank you, everybody.
Bye-bye, everybody.